So we wish to welcome you to the first presentation of the noon lecture series of the Lieberthal-Rogel Center for Chinese Studies for the winter term of 2016. We begin with a few announcements. The next presentation will take place on Tuesday, February the 2nd, and will be given by Jeffrey Moser, Assistant Professor of Art History at Brown University, who will be speaking on schema and substance in a Northern Song vessel. The photo exhibit Above Ground 40 Moments of Transformation, a photography exhibition highlighting the powerful performance art and actions of Chinese young feminist activists, will be on display in the Lane Hall gallery space through the winter term of 2016. This exhibit is open to the public. On this coming Saturday, January 30th, the CCS Chinese Film Series will present Rape Amnesia, a 2014 film by director Wang Xiaoshuai on the reflections of an older woman on the Cultural Revolution in a current environment of intergenerational disparity. This film will be shown at 7 p.m. in Auditorium A of Angel Hall. It is free and open to the public. We would appreciate if you could please take a moment to turn off your cell phone before the talk begins. So today's presentation will be given by Professor Benjamin Liebman, who is the Robert Lieff Professor of Law and Director of the Center for Chinese Legal Studies at Columbia Law School. We must thank Professor Liebman for braving the post-blizzard weather and taking a 6 a.m. flight to get here. So I'm very delighted that he did arrive here. His current research focuses on Chinese tort law, criminal procedures, the impact of public opinion and populism on the Chinese legal system, and the evolution of Chinese courts. Professor Liebman has many publications, including Regulating the Visible Hand, Leniency in Chinese Criminal Law, Legal Reform, China's Law Stability Paradox, Malpractice Mobs, Medical Dispute Resolution in China, and many other chapters and articles. Today, Professor Liebman will be speaking on Is There a Chinese Model of Legal Reform? So please join me in welcoming him.
Great, thanks so much. It's great to be here, especially because for a while it did not look like I was going to get here, given the transport system, but I did, and it's great to be here. So as Yuan said, I'm going to talk here about sort of recent developments in the Chinese legal system. Since Xi Jinping came to power more than 3 years ago, there have been two prominent storylines about China's legal development. The first one is the one which has been in the media a lot, especially in the last couple of weeks, a significant increase in repression with detentions, prosecutions of rights activists, in particular lawyers, often accompanied recently by televised forced confessions. Much of this repression is carried out with little regard for China's own laws, in particular for China's important revised criminal procedure law, which came into effect just a couple of years ago. At the same time, however, China has begun very significant and potentially far-reaching legal reforms, in particular in the courts. These reforms are the most significant reforms undertaken in China's legal system, I think, in decades, and are often cited as giving some content to Xi Jinping's commitment to build a, quote, 法治中国, or rule of law or rule by law China. The reforms in the courts have led some in China to argue that China is now clearly developing a uniquely, quote, Chinese model of legal reform. But these reforms also give us outside of China an opportunity to sort of rethink Chinese law and governance and to rethink how China fits into existing theoretical models, in particular of authoritarian legality and governance, and to ask what if anything, distinguishes the roles that law and legal institutions play in China from other countries. So I'm going to start my talk today with an overview of recent developments in the legal system and some of the challenges that the current reforms are encountering. I'll then spend a few minutes talking about how some in China are framing recent developments as a uniquely Chinese approach to rule of law. And I'll conclude by trying to sketch what I see as key characteristics of the roles courts play in dispute resolution in China. All right, so let me add just sort of two disclaimers. The first is that most of what I'm talking about today is about the courts, and of course courts are just one of the many different actors in the Chinese legal system. There are two reasons I'm focusing on the courts. One is it's where most of my research focuses, so it's what I know the best. But it's also where the most important reforms right now are underway. The second is that much of what I'm talking about reflects some various different projects that are very much works in progress, so I also look forward to your comments, suggestions, and questions. All right, so first, on recent developments. Most Western media discussion of developments in China, in particular in the legal system in the last couple of years, have focused on the crackdown on civil society, and in particular, as I said, on activist lawyers, on the fight against corruption, and on the recent tightening of political control. Now, recent developments in China certainly deserve this attention and certainly deserve the level of scrutiny they're getting. We're seeing, I think, a level of repression and ideological control that we haven't seen in China in a couple decades. At the same time, however, China has also embarked on serious efforts at deepening legal reform, in particular in the courts. Some of these reforms go back a couple of years, almost 3 years, but most of them draw their impetus from the Communist Party's fourth plenum in late 2014, which focused on the legal system. The reforms announced thus far are wide-ranging. If you go back to the fourth plenum decision in October 2014, they actually sketch out 65 different reforms to the legal system. And since then, we've seen a huge emphasis on reform coming out of the Supreme People's Court, China's highest court, the Communist Party's Central Political Legal Committee, and in a few cases, the Communist Party's central office itself. Let me highlight 6 of what I think are the most important reforms that we're seeing right now in China's courts. And some of this is probably a little bit detailed for those of you who are non-lawyers, but I'll try and make it not too legalistic. The first, reforms underway right now in China are moving to centralize court finances and the appointment of judges and procurators at the provincial level. So putting control over court budgets and the appointments of judges at the provincial level instead of at the local level as in the past. And this is really important because in the past, a lot of the concern about local protectionism in China derived from the fact that local governments controlled, or local party organization departments controlled not just appointments, but also court budgets. And so this is a real attempt to go after local protectionism. Second, reforms underway right now, and in fact, they just announced they're rolling them out nationwide this past weekend, will dramatically reduce the number of people classified as judges. With only 39% of currently there are 230,000 people in China with the title of judge. That's a huge number. The U.S. is about 25,000 judges if you include federal and state courts. So huge number of people classified as judges. They're going to shrink that so that only 39% of the people with that title continue to hold that title. The idea here is to separate out the judicial role from the administrative role. The Supreme People's Court in China has 500 people classified as judges. Most of them are not engaged in judging. There's a huge range of different activities that go underway. So the idea here is people holding the title of judge should be engaged in judging, and the others, the administrative people, the people doing research, will not hold that title. Now, as I said, this is already underway, especially in Shanghai, where they've started literally to cull the people who are classified as judges significantly, and it's going to be expanded nationwide. Third, there are now multiple experiments underway, both at the provincial level and to a limited degree nationally, maybe starting to happen, with the creation of cross-jurisdictional courts to address local protectionism. Right? The idea is to go after the problem of local courts protecting local actors, in particular protecting local governments. And so, for example, we've seen in Henan province, where I've done a fair amount of research, administrative suits, those are suits against local governments, have uniformly been moved out of the local jurisdiction of the entity being sued. So it used to be you bring an administrative suit against the local government, right? You sue them in the local court. Guess what? It's hard to bring that suit. So now all of those suits are now being brought in other jurisdictions, still within the same province. And Beijing, Shanghai are now creating, in a sense, cross-jurisdictional courts within those municipalities to deal especially with administrative suits. Fourth, as of last May, Chinese courts have been forbidden for engaging in substantive review of cases at the case filing stage. All right, so what does this mean? Case filing is a particular stage. In the U.S., it's a very administrative action. You go and you file your papers. A court clerk accepts your papers, right? In China, in the past, the problem was you'd go to court, and the case filing division of the court, if they didn't like the case, would simply refuse to accept it, right? There was, in effect, a substantive review of cases. So if it was a sensitive case or even a difficult case or just a case bringing suit against the local government, often the case filing division would simply refuse to accept that case, right? They now are not allowed to do that. And this involves two steps. One is that local courts are no longer allowed to engage in any substantive review of the merits of a case at filing. They must file the case if it meets the procedural requirements for filing. And it also means if they reject a filing, they must give you a reason for rejecting that filing. They must tell you why. So is this going to be effective? We don't know yet. But what we do know is that in the first, 8 months now since they did this, we've seen a huge increase in caseloads in China's courts, in particular in administrative cases. So there is some effect going on already. Fifth, last spring, the courts, together with the Central Office of the Communist Party, announced the creation of a reporting system for officials who interfere in the courts, with courts required to record any efforts to interfere in court decision-making. Not surprisingly, there's a lot of debate about how effective this is, right? If you're a local judge and the local party boss calls you, are you really going to record it? But maybe that doesn't matter, right? Because maybe the important message here is that they're saying to local officials, this type of interference, which was routine in the past, is not okay anymore. And maybe the conveyance of that message starts to have some effect. There's actually some other interesting nuances in how this policy is being implemented that I can talk about later on if you have questions and we have time. And sixth, and the last of the reforms I'm going to mention, we've seen a continued push towards greater transparency in the courts, something that started a few years earlier. Over the past 2 years, there's been a dramatic increase in the volume of cases available online, so that right now, if you go to the Supreme People's Court website, you'll find about 18 million cases that have been made public since 2014, about 7,000 to 8,000 new cases being posted every working day. There are big limitations to what's being made public, so transparency is not 100% by any means, and I'm happy to talk about that later on, but I think there has been a significant and important push in the direction of greater transparency. All right, there are other reforms I could talk about. In the interest of time, I'm not going to go into more detail about them, but overall, I think it's fair to say these reforms reflect a serious push to make the legal system higher quality, more efficient, more fair, and more transparent. Now, many of these reforms have not received extensive attention outside of China. I think there's a sense, if you look at both popular writing and also some of the academic writing, that the spike in repression in China proves that the Chinese leadership is not serious about reform. And it's certainly true that the reforms are going to have little effect on the wide sphere of politically sensitive cases. And as I said before, I think the current wave of repression and detentions is extremely worrying. But I think it's also a mistake to see serious legal reforms as in tension with this increase in repression. I think there's clear separation of what can and cannot be reformed. And indeed, from the perspective of the central leaders, I think to some degree, repression may be a precondition to reform. I think there's a clear effort to delineate what is permissible and what is not permissible, with the scope of what is permissible being shrunk. But it's also important to highlight some of the limitations of current reforms and actually some of the problems that we're already seeing reforms encountering as they're being implemented. Some things are easy, right? Some things that courts can do on their own, putting cases online, for example. I mean, the courts can decide what cases to put online largely on their own. They can make it easier to file cases on their own. But other types of reforms are much more difficult, right? Reforms announced thus far don't affect the authority of courts compared to other party-state institutions. And these reforms, I think, are really about making courts work better, not about giving them more power. So courts, I think, in China can make themselves more open, more fair, and perhaps more competent, but reforms can do little to change the fact that courts remain weak actors in the Chinese political system. I think it would also be a mistake to see reforms as reflecting a fundamental change in how disputes are resolved in China. Populism, for example, remains extremely important, as does stability maintenance. In fact, Xi Jinping just gave a set of comments over the weekend in which he reaffirmed the importance of stability maintenance work, which many interpret as meaning instead of law. But I'll come back to these themes in a couple of minutes. And reforms are also encountering opposition within the court. So we might think, right, the judges in China are going to be really excited to have these reforms that make it easier for them to do their jobs fairly, and that's not quite the case. So for example, I mean, the biggest area of contestation has been actually the shrinking of number of people classified as judges. We've seen a dramatic increase in resignations in the courts. Lots and lots of young judges are resigning, and this is problematic because often the youngest judges in China are the most competent, the best, the most legally trained. And why are they quitting? Well, they're quitting because they don't see the possibility of career advancement. Now, again, the story is very different depending on where you are in China, but that is a problem, and it's gotten a lot of attention in China of late. But also, I think, and perhaps a little bit less easy to measure or to observe, it may not be the case that judges actually welcome reforms that make it easier for them to rule against local governments or that make them free from oversight from local officials. We have to remember that judges in China operate in a complex system in which they also benefit from relationships with party-state leaders. And it may be more difficult than we expect to break these links. Academic critics within China have also noted other limitations to legal reforms, right? Some have criticized the speed of reform, saying that, the speed suggests maybe the central leadership just wants to get this implemented and over with. As others say, the system can't absorb so much reform so quickly. But I think a more nuanced critique is also that these current reforms reflect a methodological shift away from reforms based on experimentation and experience, right? And the argument here is that a lot of what China succeeded with over the past 30 years has been based on, ground-up experimentation. For those who, 从点到面, right? This using experiment at the local level and then spreading them nationwide. A shift away from this to a top-down, centrally controlled reform effort. It's been another critique that's been made in China. Now that said, there's been some criticism within China. Voices hailing the importance of these reforms have been, maybe not surprisingly, much louder, both within academia and in the official media. And I want to just focus today on one important strain of argument in China, because I think it's been little noticed outside of China, which is the claim that China is now developing a unique approach to legal reform. Now, of course, the idea that China has its own unique approach to economic or political development or to the creation of some form of rule of law is not new. What I think is new here is the argument that the Chinese approach to legal reform is not only normatively better for China, but also may be exportable and relevant for other developing legal systems. So the claim, at least the argument I'm making, is that what we see here now is an emerging parallel argument. We've seen in other spheres arguments that China may be trying to export its authoritarian development model more generally. I think we're now seeing a subcategory of this, which is in the legal sphere, right? Similar argument amongst some legal scholars. These arguments reflect a shift from mainstream views in the 1990s and 2000s that took it as granted that the appropriate yardstick for evaluating legal development was a Western liberal model. Thus, what in the past might have been portrayed as problems or limitations of the legal system in China are now described as important positive features of a Chinese approach to legal reform. Now, Chinese scholars who articulate these views don't just reject Western models. They're also trying to provide a detailed account of what makes China unique. And I want to be clear, actually, that I think this is a serious effort by serious scholars. So I'm not putting this forward to discredit. I actually think this is an important effort, and I actually have worked closely with some of these scholars. I think it's important to try and do this work. But I think it's also notable to see sort of the political side to this, the effort to maybe talk about this as an exportable model, right? So what are these factors? I don't have time to go through all of them, but just to say, we see scholars in China saying things like, the emphasis in China on law yielding at times to concerns about social stability is an important characteristic of the Chinese approach to legal development, or that China has a particularly has a form of judicial independence, which is a limited role of judicial independence with all legal institutions subject to party leadership. Increased emphasis in recent years on China's own legal traditions. That's new, right? Saying a positive aspect of the Chinese approach is reliance on its own legal traditions. I think 10, 20 years ago, we didn't see Chinese officials articulating that view to anywhere near the same degree. Arguments that the party state is engaging in self-supervision and restraint, but also arguments that Chinese approach to the rule of law includes increased legalization of the party itself. So again, not law as a check on the party, but law serving internally within the party to regularize how the party functions. And there are others, things like arguments that individual rights need to yield to stability concerns, or that it's legitimate for courts to consider extra legal factors, right? Of course, some of these arguments, and I have a paper on this that talks about it a little bit, some of these arguments obviously become circular, right? To say that a central characteristic of judicial independence in China is that it's led by the Communist Party, I think doesn't get us very far in identifying, what is unique about China. And I just want to point out here, I think one of the important questions that's often not asked in these articles and these debates is whether China can develop mechanisms that regulate when China yields to politics, right? Even assuming continued Communist Party rule, the question I think still remains, can China develop some norms that determine when courts are going to yield to politics? I don't think those exist at all right now. It's certainly not to say I think that would be a desirable outcome, but I think you need to engage these arguments. All right. Now, of course, the idea that China is not, converging with Western models is not novel. A number of people in this room have written on related topics, but I do think it's important to note this shift, right? From saying that China needs more time to develop robust legal institutions that are in line with international standards to saying that Western legal institutions would be problematic given China's historic traditions and political environment. All right. Now let me turn to the third question I posed at the beginning of my talk, which is what do I actually think, if anything, makes China's approach unique, both in terms of the role courts play in the Chinese political legal system and in the role Chinese courts play in Chinese society. Another way to put this is, what's missing from recent accounts in China that have begun to attempt to define a Chinese model, although, as you'll see in a minute, some of what I say actually overlaps with some of these arguments, right? So I certainly agree with those in China who've argued that we're not seeing and we are not likely to see convergence with Western models. The more interesting questions are what roles the Chinese courts actually do play in the Chinese system, and whether these are in some ways distinct from efforts to build legal institutions elsewhere, in particular in other authoritarian legal systems. So what I'm going to offer you today are some preliminary thoughts on this that I hope will eventually evolve into a larger book project on China's courts. So China's goal of constructing a legal system that enhances the legitimacy of the state, maintains social stability, encourages economic development, but also does not permit challenges to the authoritarian system is less unique than many in China suggest, something reflected in the extensive Western literature on courts and authoritarian systems that has emerged in the past 2 decades. Right? The idea that law serves primarily as a tool of the state, not as an organizing principle for society, is of course common across many other systems. Likewise, the tension we see in recent years between serious commitment to legal rules and reforms in routine cases and political cases that often, if not almost completely, ignore the law is by no means unique to China. Right? I think one of the most powerful critiques we see of what's gone on in some of the political cases in China in recent weeks is very clear that China is simply not following its own legal procedures, especially the criminal procedure law, at all. Right? But this isn't unique to China, right? No, I'm certainly not an expert in other systems, and then not going to claim that I know that China is or is not distinct from other authoritarian legal systems that have drawn extensive study in recent years. But I think there are some important descriptive characteristics of the Chinese legal system that may help to begin to answer the question and, perhaps more importantly, may provide insight into the role of legal institutions in the Chinese political system. And I think it's worth pointing out, I think many of these are omitted from recent accounts by scholars in China who've begun this important work of trying to articulate a theory of a Chinese model of legal reform. All right, so let me try and highlight 6 components. I realize I gave you 6 already. I'm giving you another 6 of the roles. That's the law professor, right? We're going to give you 6 points, right? The 6 components of the roles courts play, and I think don't play in China, that I think are important to understanding role of courts in China, but also I think are important to beginning to build a theory of the role of courts in the Chinese political system. And I want to add that I think what's perhaps unusual about scholarship on Chinese courts compared to other systems is that there's been so much work or starting to be a good amount of work at sort of ordinary cases and sort of real good low-level empirical work. I think that distinguishes a lot of the work that's being done in China from the work done in other authoritarian systems. And I think that methodologically, any attempt to understand the roles courts play in China needs to focus on routine, ordinary cases. All right, so first, I mentioned before, right, that China is certainly not the only system in which there's maybe a distinction to be drawn between routine cases and political cases. But the separation of routine cases where courts maybe have the ability to operate fairly and according to legal norms from political cases where courts have little decisional power on their own remains extremely murky in China. The scope of what is politically sensitive in China can be extraordinary, not just explicitly political cases, but cases linked to local economic interests or even cases involving the threat of a single protester or petitioner. So arguments that China is following other authoritarian systems and separating out political cases from routine cases, I personally think make little sense given the breadth of potentially sensitive cases in China. Efforts to restrict external intervention in the courts that we've seen lately coming out of the courts and out of the Central Party office are clearly an acknowledgement of this problem, but I think are unlikely to be an effective solution. Second, law, and maybe I think this is unusual, at least in the degree to which this happens, law continues to operate in the shadow of stability concerns and violence. I just wrote a piece called Law in the Shadow of Violence about medical disputes in China. In a range of cases, the threat of protest and violence is the most important factor leading defendants to settle cases. So again, to take the example of medical disputes where I've done some work recently, right, I mean, it's very clear that the threat of violence often leads defendants to settlements, to settle cases well in excess of what any compensation that would be available to plaintiffs in court. But this dynamic I think also exists in other cases, labor, other areas as well. But medical cases is one area where we see this very clearly. A third, despite significant efforts and one could say renewed efforts to encourage greater use of normal laws, and despite the massive effort that's gone into building a code of substantive laws, right? Really wide-ranging creation of substantive legal norms, of detailed laws that have come on the books in China over the last 30 years. Populism and mass-line ideology continue to play important roles in shaping outcomes inside and outside of courts. So although we've seen a dramatic decline in the reported number of court-related petitions, right, in effect protests, in the past few years, the threat of petitioning and protest remain an important determinant of court outcomes and of the evaluation of judges. So I think one of the things we've seen of late, right, is the party state has been more coercive in its response to petitioning. This reflects a new approach to managing public opinion and dissent, but not a lessening of concern about individual discontent and public opinion, right? So I can talk more about this later on. I mean, what we're seeing now is courts really becoming much more effective at stopping people protesting court decisions by jailing them, right? And this is what's happened in the last 2 years dramatically. But that doesn't mean that the party state is not concerned about protests. They're still incredibly concerned about popular discontent, and courts are very concerned to the degree which I think is rather extraordinary about even a single individual being unhappy about a court opinion. All right, but again, it's a complex issue. It takes more than 3 minutes to summarize, but I can come back to it later on. All right. Fourth, judicial expansion of authority in China and innovation within the courts is often the result of efforts to shirk responsibility, not to expand court power. Right? So what do I mean by this? So we see a lot of actual innovation in the courts in China, and sometimes innovation in the cases that courts are allowed to bring, that is decisions by others to give courts the ability to hear other types of cases. But I think this is often done in ways that are actually attempts to reduce pressure on the courts or on other actors, not to actually give courts new power, right? Let me just give you two examples. So in medical cases, you see a lot of doctrinal innovation, courts making new legal rules, but they're not doing this to grab new authority. They're doing this to avoid problems, right? They're creating new legal rules to try and avoid pressure on them, to avoid protest. And why this is interesting is that I think often in West, in the legal literature, we think of courts that innovate, that create new legal rules. That's often equated with courts grabbing new authority, grabbing new spheres of influence. That's not what's happening, I think, largely in China. And likewise, we've seen areas such as some of the issues in land disputes, Taitian, housing demolition, compensation, where externally it looks like what's happening is they're giving courts a greater role, for example, in approving the level of compensation to people who've had their homes taken. And that looks like giving courts more power. But what may actually be going on may be an attempt by other party state actors to avoid responsibility, to put the pressure on the courts, to blame the courts, maybe to claim some legitimacy from courts. And I think this is a really interesting and different dynamic that we see elsewhere. And for this reason, I think it's also clear that dramatic increases in caseloads in Chinese courts that we're now seeing, especially the last year or two, do not mean courts have more power. Fifth, and relatedly, courts continue to be embedded within a web of party-state institutions that are at times competing for influence. But it's important to remember, despite all this attention to court reform, the courts remain quite weak actors. I was going to say incredibly, but I don't want to say incredibly. Very weak actors in the Chinese system, and this is reflected very clearly at the top, right? The fact is that head of the courts, the head of the Supreme Court is not that high ranking, certainly not in the top 25, 30 people in China, right? And a lot of people in China think that unless you actually, can get someone from head of the courts into the Politburo, it's pretty hard to see the court's roles actually increasing dramatically. And of course, that opens up other complexities. Large reasons to think that won't happen. Sixth, courts continue to be just one route for resolving disputes, with state-directed efforts to manage disputes through multiple channels continuing to be important, even as more disputes wind up in the courts. So, and of course, most disputes in most countries are resolved outside the courts, right? It's not the case, even in the United States, we don't litigate everything. But it's important to remember, in China it's different, right? This is state-managed dispute resolution, steering disputes into a wide range of different dispute resolution institutions. And despite all the emphasis on court reform of late, there's little sign of any effort to make courts anything more than one among many channels of dispute resolution. And for those of you who are from China or study China, right, this emphasis we've seen the last year on multiple methods of dispute resolution, I can't even do the words in English, we've come out in the last year show, I think, that their state is still very much playing an important role in managing disputes. In fact, the most important document about dispute resolution that's been issued in China in the last year came out in December and is not public, which I think gives you some sense of how the state views dispute resolution more generally. The fundamental goal remains to resolve disputes, not necessarily to resolve disputes according to law. Right, so what does identifying these 6 characteristics tell us about the ongoing extensive reforms to the legal system? I think it shows that reforms will not fundamentally alter the position of courts in the Chinese political system. None of the characteristics I just set forth appear likely to be altered by the current wave of reforms. Rather, the current reforms are expected to make the courts better at playing the roles they already play. Some scholars have suggested that the volume of cases in China's courts suggests that courts are becoming fundamentally more authoritative. But I think it's also important to recognize that factors identified as important in the rise of courts in the West, especially in the post-war period, simply are not present in China. Courts in China continue to play no role in resolving important political questions and very limited roles in rights protection. The fourth plenum reforms are not altering this dynamic. But China is also different from other authoritarian systems where much of the development of courts has come from high courts expanding rights protections. Again, this is not a dynamic we're seeing in China. That said, the scope and seriousness of recent reforms does, I think, raise a number of intriguing questions. If courts do become more fair and more competent in the eyes of ordinary people, will that give them more public support and legitimacy and make courts more authoritative or influential within the party state? Can courts expand their legitimacy and influence simply by being fair in routine cases? Or will successful reforms simply mean that courts are a more effective tool for the party state to use in managing society? Can courts that are subject to new rules on things like case filing avoid taking on more important roles, including as sites of contestation for important questions of the days. I think that we're likely to see a whole range, even in the current political environment, we're likely to see, and even to some degree have started to see, some really innovative, interesting cases being brought. And of course, at least as formally written, courts now have to respond to those cases in a way in which in the past they could have just ignored them entirely. So, that's a very interesting issue to watch. It's too early to see how important this is, but I think we're starting to see this. And I think, for those of you who study Chinese law or are familiar with it, administrative law is clearly the area to watch here. To what degree are courts now really going to be forced to take on a dramatic increase in both the number and scope of cases brought against local governments? All right, so I think as you might have guessed by now, over the last 35 minutes or so, I'm somewhat agnostic on the question of whether we can say that the role courts play in China or the Chinese state's approach to legal reform is unique. If there is something unique about how China's approaching legal reform, I think the uniqueness of the Chinese approach is not from the mere fact of attempting to create a functional legal system that serves the goals of an authoritarian state. It's from how the legal system fits into China's Leninist political structure and culture. But I think it also comes from the everyday experience of law, which continues to include flexibility in adjudication, a large degree of experimentation even after the implementation of top-down reforms, a lot of populism and popular input, responsiveness, and a good deal of protest and violence. Indeed, I think this extreme responsiveness in adjudication, right, this idea that courts are worried not just about the threat of widespread protest about their cases, but are worried about the individual litigant who protests outside the court, and this continues to be the case, right? A single aggrieved individual is perceived as a threat to court legitimacy, right? And this produces a high degree of responsiveness. This concern with removing all possible sources of social contention certainly distinguishes Chinese courts from Western liberal models, and I suspect also distinguishes China from many other authoritarian legal systems. Put differently, if China is in some ways unique or is beginning to develop to some degree a unique approach to legal reform, I think it's not the mere fact that it's serious about legal reform, but rather that it continues to construct a legal system with this unusual blend of socialist legal institutions, borrowing from a wide range of Western countries, also extensively from Japan, Taiwan, Singapore, Chinese tradition, with and also a strong role for popular participation and populism, which really has its roots in mass line ideology. So although the promise of law without democracy will of course be attractive to some elsewhere in the world, there are many reasons to be cautious or to doubt whether China's approach to constructing a legal system has relevance elsewhere. The most important question is not whether there is a Chinese model, it's whether the reforms being rolled out right now can work in China. And I think the answer to that question is at present, it remains extremely unclear. Right, so with that, let me stop and say thank you, but then I hope also open it up to questions and suggestions and comments. Thank you. Go ahead, yeah.
Thank you very much for your interesting lecture, Professor. Who's the main driving force here in what reforms are taking place? Is it the Communist Party per se, or is it, let's say, legal scholars and law professors at Chinese law schools?
It's a good question. So, I think there's a lot of different dynamics. So at the top, clearly, the new impetus reform comes from decisions of the very top leadership, right? And the most important, reform documents are coming out of the party. Actually, there's a leadership small group at the very top level overseeing all of this reform. But what does this draw on? Of course, this draws on, a lot of what's been done over the last 20, 30 years, importantly by Chinese academics and participants in the system. So I think the general outlines are being done at a very high level, but a lot of the specifics are being done, both within the courts and some degree with academia. Although when I was there 2 weeks ago, there was a criticism from some academics. There was a sense that maybe, the reforms are drawing less on academics than they used to. I should say though that I think also what's happened is that the courts, and in particular Zhou Chang, the head of the Supreme Appeals Court, has really run with it. Right? They have perceived an opening to really push through some of the reforms that they've wanted to do for a while, and they're running with it. And this explains why, for example, we're seeing a lot of reforms in the courts, but very little in the procuracy, right? The procuracy equal level to the courts in the Chinese system, both an oversight role and also the prosecution, and almost nothing coming out of the Ministry of Justice, which oversees lawyers, right? So this is, so I think part of this is the individual institution, but I think that specifics, there's some degree of the specifics which are things Chinese academics have talked about. I think academics have been more influential at the level of substantive law, right? Actual, criminal procedural law or tort law or whatever. But some of this is stuff people have been talking about. So if you just give an example, right, the cross-jurisdictional courts, that's an idea that has been talked about for a long time by Chinese academics as a way of getting at local protectionism. But it's really because the center's gotten serious about this that they're coming at it. Go ahead. I don't know if I say excited. I think that I think that there's some. So I think there's different types of innovation. So I think one type of innovation, as I said, is just creation of new legal norms. Right? There's this idea that judges don't make law. Right? Of course, judges everywhere, including in civil law systems, make law, and so there's a lot of substantive innovation where judges, either there's two types. Either because the legal space is unclear, they got to make up legal norms, or sometimes they actually, I think, innovate to violate legal norms. Right? They expand. They'll hear types of cases that are not clear they have the jurisdiction for, or they'll simply make up new legal rules as judges do elsewhere. So that's one type of innovation. The second type of innovation, which is more structural, right? And this is where I think we may be seeing less of it. So where courts have done things on their own. Best example I've written about of late, right, is that the impetus to put cases online comes from the courts in Henan, which now 6 years ago suddenly decided to order all courts to put, to have a default rule being that cases should go online, right? There was no central direction for that. It's not clear if it was done with central approval or not, but that was a local innovation, which I think is very important, and actually I think led and pressured other jurisdictions to follow suit, and then led the Supreme People's Court to put cases online. And then there's a third type of innovation, which I mentioned, right, which is actually a decision by others, by the party or by legislators, to give courts certain authority over certain cases. And I was questioning whether that, what I was trying to say is I'm questioning whether that type of decision really is about giving courts more power. Sometimes it may be about, making courts responsible for things other people don't want to be responsible for. Let me keep going this way. Okay, go ahead.
Thank you, Professor. I'm very interested in the question is, as we know, there's a paradox about the party increasing the legitimacy in the court reform. Do you think giving courts more authority so that it can impose checks and balance on other branches will become a future legal reform direction?
Sorry, giving other branches?
Yeah, like giving, so imposing checks and balance
Yeah.
in other democratic countries in Western world.
So I don't think we're going to see that, right? And I think that's not what's on the agenda here. I got off track because as you were talking, I started thinking about Professor Gallagher's work, right? Because I thought you were going in a different directions. I thought you were going to say, is there a risk to them, right? That you roll out all these reforms and there's massive popular disillusionment, and that's a big risk as well, right? And part of the reason we're seeing these reforms is I think they realize that they got a big problem, right? And that the popular disillusionment with the system is so extensive they need to crack down on it. I think it is extremely clear if you read the fourth plenum document and you look at what's come out, that this is not about checks and balances or judicial independence as we think of this. It is very clear, and I think in fact one of the interesting arguments we're seeing in China now from scholars, in particular on the left, but again these are serious scholars, and many of them actually trained at Columbia, right? So I should these are people who I think are really trying hard to think about what it means to have a legal system in this type of political system. These are not people who believe that this system is the right system. They're people who believe this is the system, and they got to try and figure out how to work within it. But I think this is about, this is why they've talked about, party self-restraint, right? It's not about checks and balances. This is about how can you curb abuses without having checks and balances on the party. And of course that's paradoxical. And of course the most important institution is the one I haven't mentioned at all in talking for almost an hour, right? Which is the party disciplinary authority, right? And so parallel to everything I'm talking about, we have this massive crackdown in corruption, completely extra legal, right? No legal basis whatsoever going on, and that's another. So I think, and so I think it's the party is sending mixed messages here. On the one hand, they want to stop abuses. They want more rules. They want more rules both within the party and in the legal system. But that doesn't mean giving the legal system, final say over what's going on within the party at all. I think that's very clear.
So, you mentioned that there were references made to the Chinese legal tradition, and
Yeah.
you mentioned the contrast between routine enforcement of rules that goes on, which is relatively non-political and then, the political cases. I can't, as an imperial historian,
Yeah.
can't help thinking of the distinction between routine memorials and palace memorials, where the latter were reserved for political cases, more sensitive cases. And do you see any conscious reference being made to that?
That's great.
Either to justify or to explain among Chinese legal scholars?
So that is great. And I thank you for that comment. No. I mean, I have to say, I have to say, I have not done. Sorry. So the question is a great question from a historian, which is not just is there, when they draw on legal tradition, are they drawing also on this legal tradition, which, did separate out the special from the ordinary, if I can put it right, and routine, the palace, so routine morals, palace morals. So I have not sat down and really engaged this literature, right? I've just been struck to suddenly see senior officials suddenly start talking about China's own legal tradition as a positive contributor to this Chinese model, right? But I don't think it gets to that level. But it's a really interesting question, whether the historians would use this, as a justification as well. I don't think, I'm guessing no, but I haven't read enough of it. But it's a really interesting question. So I will set a great, research assistant on this question. It's, and I will get back to you. No, it's great. It's a great question. Yeah, it's great. I will, absolutely. Go ahead. Go ahead, yeah.
One thing I've heard in your discussion about the courts is the courts as an institutional arm of the state. It's a discourse that's very familiar to us outside of China. But of course, there's this other side which has not come up as strongly in the talk, which is the party.
Yeah.
And I'm wondering, we can talk about the courts separately, but they're part of a system that's coordinated by political legal committees.
Yeah.
And the membership of those political legal committees, and in particular the leadership, is also changing. And there are various people who watch these things closely who notice a shift away from Public Security Bureau domination. And so I'm wondering how, the courts, of course, are just one organ of a bureaucracy, and they're coordinated by higher organs, which are largely party organs. I'm wondering how these multiple pieces fit together, where the political legal committees fit into this process.
Yeah, right now. And so obviously, for obvious reasons, it's harder to get a good sense of exactly what's going on in the political legal committees. Clearly, they're still very important. And what people say is so the party, for those of you not deeply entrenched in thinking about this stuff, party has within the Communist Party has a political legal committee at every level of the party state. Generally, traditionally, has been headed by the local public security person, although there's a shift away from this, but it plays a coordinating role. Clearly, there's been a shift away from the political legal committees getting involved in individual cases, but there's no question that they still coordinate really important cases, I think. So they're still there. It's hard to get a read of whether, for example, court presidents are getting more important there. And of course, I think part of the answer has got to be it's too early to tell. So in the past, right, the political legal committee exists. Let's say you're at a county level, you got a party political legal committee with the head of the procuracy, the courts, the police, the Justice Bureau. Right. One of the interesting things now is that court person is not going to be drawn. It's not going to be someone put in that position by the local party organization department or even the next level. It's going to be 2 levels up at the provincial level, right? So how does that affect the dynamic in that political legal committee where you have, in effect, someone who's not embedded or doesn't have their roots within that local political culture coming in? We don't know, right? So that's one answer. I don't think we know. I don't think this anything here reflects a fundamental shift away from general oversight by the party over this stuff. I think there is an effort, and a serious effort, to say to local party leaders, don't get involved in individual cases. Now, a lot of scholars in China say it doesn't matter, right? I mean, there's so many ways in which courts and judges, especially court presidents, interact with local elites that maybe they don't need to be told how to decide these cases. I think the one area to watch though is, I think the courts are also pretty savvy about some of this stuff. So the SPC, again, this is actually something I need to look at in more detail. The SPC has been pretty strategic in some of its reforms. So for example, although the central documents on intervention in the courts, I think, speak specifically of, not having impermissible forms of intervention, right? One of the things the courts did is that when they wrote the rules on recording intervention, they basically made it so that you had to write down any time someone inquires about a case, including legitimate cases, right? Which might include, it might be okay for the political legal committee sometimes to check on cases. And the idea here was to make it so routine that you record every contact that it actually forces you to record the illegitimate types as well. I'm not sure that's going to work, but I mean, so I think they are thinking about this at some level. But I think we're not seeing a fundamental change in the political culture that's a backstop to how the courts function, if that makes sense. I think it's and I haven't obsessed as much as some about questions of rank and whether the head of whether we're seeing a demotion of the importance of political legal committees. I don't know, but I think that and I come back to this point that maybe it doesn't matter because there's so even if you have a slightly different rank, there's so many different ways in which court leaders in particular are going to interact. But I think it's going to be really interesting to see how this process works with judges no longer being drawn or approved by local organization departments.
So I have a question going back to the reforms that you talked about, because it seems like even that you're talking about them now as well, in the sense that if you just describe them, they sound pretty revolutionary, right? And they're kind of technocratic in a way. There's sort of institutional reforms to change the way the courts function, like this elevation to a certain level for appointment. But we're sort of cynical now about them because at the same time we see this repression going on among rights protection lawyers in civil society. But so, for example, right now with detention of labor activists, there was an article this morning in the Guardian saying that some of them, and most of them are trained lawyers, are suing Xinhua for slander. Because apparently if you're a rights activist in China, you also sleep with 8 women at a time, just like So basically they found a way to crack down on rights activists is to find something in their past and then they're sort of prosecuted in a way of lifestyle and mistakes. And that reminds me actually of Singapore and Malaysia, where we do have a different type of rule of law, but the party is still using it to its own advantage. But getting back to this idea of using, you have people at the bottom, these lawyers at the bottom who are trying to use the legal system in a much more strategic way and trying to take the legal system to advance their own interests. So using it, I think suing Xinhua for slander or for libel is a sign that society is also sort of going to react to these reforms in a way that could still be unacceptable.
So I agree, and that's part of the question I raised at the end. I mean, can you really constrain this? And I want to say, I think this stuff, so I think the way you phrase it is important. I think these reforms are really important, and we have largely missed how important they are, right? And I think for those who are students here, there's a massive opportunity for interesting empirical work, because you got 65 different reforms. Any one of those can be looked at in the next few years. This is sort of what I was trying to say at the end is, on the one hand, it looks like they're constrained and they're not that big. On the other hand, we don't really know, right? And I think they're also, the people within the system who want to unleash these forces. So I think there's a lot going on here. And some of these, look at it, again, administrative law, there's a lot going on. And suddenly what happens when governments get sued a lot more? And, some of this may be form over function, right? There's efforts to say, okay, defendants, meaning the local government officials, actually got to show up in court, which they never used to do, right? That may be less important, just the fact that the courts have to take these cases and have to start to engage. And as they engage doctrinally with substantive legal, new types of questions, maybe this has some effect, right? I agree. But I think there's another flip side. So the other thing I was going to say is there's a real parallel to what you're describing, though, also to the petitioning situation, where we're now seeing what I think is actually like I call like a one-offer system, right? So it used to be you have these repeat petitioners over and over again, right? And what you see to be happening now is basically, you petition, the government makes you one offer, and you take it or leave it, right? And if you leave it and you keep petitioning, then you're prosecuted for extortion, right? So we've seen a bunch of cases the last few months. We've gotten coverage in the Chinese courts where petitioner asks for $1 million, they offer him 100,000, the petitioner asks for $1 million, they say you're trying to extort us, and they give him 10 years. And so we had a couple cases of 10 years. We had someone get life sentence recently in one of these petitioning cases. So that's also a change. So I think this is different. But that also to me sounds a little bit more traditional authoritarian, right? it's sort of, and so there, I think these different things, but I agree, these things are all going on. There was another, go ahead, yeah.
So first of all, by the way, we actually spoke last year when I was considering coming to Columbia. Obviously, I didn't.
I'm sorry, okay, yeah. Sorry. And now you're having heard this talk, you are sure you made the right decision, right? Okay.
But so I'm interested in how this is playing. So one of the things you mentioned is that part of this goes along with some of the disillusionment, and part of the reforms might be an effort to sort of address some of the disillusionment, and part of it goes along with some of the corruption, anti-corruption moves that Xi Jinping has been making. So my question is, do you have any sense of how this has been playing in terms of both how the party has been sort of trumpeting it and advertising it, and how people have been responding to it within China?
So on the second question, I think we don't know, right? I think it's far too early. It's clear this is at the top level, although, I'm not a, there are people I mean, most of my work focuses on routine, ordinary cases, trying to look at, ordinary cases, experiences of ordinary people. And I think as we go forward, we'll be able to look at some of this in practice and look at how it's actually being used. And for example, just answering the question, okay, we've seen a 30, 40% increase in cases this year. What are those cases? Like trying to answer those basic questions. But how ordinary people perceive it, I don't know. We can all answer how the taxi drivers perceive it, right? But I mean, but it's clear it's part of state ideology in a different way from the past. Now, what I was going to say is people who study this, is the fact that Xi Jinping suddenly started talking about stability maintenance again over the last couple of weeks, does that tell us that they're moving away from the rule of law rhetoric? I'm not sure, but certainly this has been embraced at the top in a way we haven't seen before, right? The Fazhizhonghua, this rule of law, ruled by law. China, depending on how you translate it, I think is different. And the question is, to what degree does that give people trying to innovate the local level space, or to what degree is this really the center taking control of this? And so far, I think it's more the center taking control. But I think it is different than the past. And as Mary said, it'll be interesting to see how much they can constrain this. Go ahead.
As we talk about the uniqueness of the Chinese system, because I've talked to people, I've always been interested in trying to see the parallels from the Soviet system and what they inherited from the Soviet system. And I found that the Chinese don't have much awareness of that inheritance. I mean, things like the people's assessors or the laws being issued as opinions of the Supreme Court, et cetera. Yeah. And is that a valid way of describing a unique Chinese institution, even though it was inherited from abroad? Because it's very substantially different from many other systems. Yeah.
So I agree. I mean, I think that so like Louis says, part of my argument is right that what's unusual here is just this mixture of all these different things, right? But I certainly agree that there's a lack of awareness. I mean, the some of what's of these other historical roots, and so some of this is, the degree to which people in China are starting to say, hey, wait a second, maybe some of this draws on our own legal traditions, and maybe some of this draws on the Soviet side. I mean, that is also, I think, interesting and a worthwhile effort. I think there's very low awareness of this in China. I taught a course last year. There was a comparative course on China and India. Very little thinking about how experience in China and India differ. So to some degree, right, what's going on now is people are starting to sort of at least think about how it fits in. When I actually present a version of this talk in China, the talk I give is very different. It's actually, let me just introduce you to all this work that's been done on authoritarian systems elsewhere, because no one in China reads this work or is aware of it. And I think they should be aware of it, right? And so that's the version I give in China. But I think there's not a lot of awareness. Now, there is increasing legal contact. Part of, in the paper version of this, I talk about this, like legal foreign relations, 法律外交, we're seeing emerge in the last few years. And part of that has actually been increased contact between Chinese academics and academics in other authoritarian countries, Russia being one of them. So for the first time, you're seeing, top scholars in China seeming to go to Russia a lot. But I'd be kind of skeptical how much of that actually focuses on these institutions, right? I think there's a conference last year on, efforts to fight corruption, or it tends to be on fighting corruption, fighting terrorism, things like that, not on, can we think about how the roles people assessors play? And there's not, so I agree, I think there's not a lot of awareness.
Well, but it's okay to think of those as Chinese things. Those are not foreign influences anymore, right?
Yeah, I
From
think,
the Chinese point of view.
yeah, that's right. I think that's,
the EGN of the Supreme Court and things like that.
I think that's right, there's very little, I can't think of anyone I know in China who's working on sort of that aspect of legal history, right? The Soviet influence side. I don't know what time. Good. Go ahead. One.
Just
Yeah.
an interesting question about recent event. Do you think the court system will ever get involved with the fight disappearing Hong Kong and Chinese from story?
So I think in a whole range of cases, right, courts, I mean, I guess what I would question, this is maybe too lawyerly an answer, what do you mean by courts getting involved? Courts have no decisional power in these cases, right? At the end of the day, you know, we see this in the trials of Zhou Yongkang and Bo Xilai, right? Courts are involved in that they're the theater for announcing the sentence, right? But they are clearly not decisional power. I think cases like this, clearly, whatever's going on, whatever happens in the end, there may well be a court sentence, but the courts will not be the ones making the decisions. It's clear. Okay, go ahead.
It looks like the students, law students, their career path is very precarious. You can, in here, it's obvious there is a way where you either go clerk with the Supreme Court and you teach in law school and you become dean, you know, or you can be elected as a judge or appointed by the state level or the federal level to be a judge.
Yeah.
You know, what's the career path? And all of a sudden, the government decide to reduce the number of lawyers or judges.
Yeah. Well,
Precarious.
so I mean, it's a interesting and actually quite a big topic in the sense that, you know, there is a question of, I mean, China doesn't have a lot of lawyers per capita still. If you compare it to, you know, it's somewhere between, you know, what you'd find in Japan, which is a very low number of lawyers per capita, in the U.S., but it's not, by any means, it's not, it could have more lawyers. Those lawyers still tend to be concentrated in big cities, and you hear these reports of law students facing difficult job markets. You know, most lawyers in China, like most lawyers elsewhere in the world, become private practitioners. The change is that, you know, it used to be that being a judge for some subset was fairly attractive because it was still sort of an iron rice bowl position and pretty stable. Judges now are heavily overworked, they say, and career advancement is limited, and this is why you're seeing people leave. It doesn't mean, you know, for the top law graduates, they're still going to find jobs as lawyers, and the legal profession generally is still expanding. But I think there are two related issues. Maybe I'll just flag, not going into in detail to this. One is, but China's really diverse, right? And so on the one hand, we can say, okay, you know, if you people don't want to be judges in Beijing or Shanghai anymore. There are lots of places I was with a judge recently somewhere else in China who said, this is just not an issue for us. We couldn't find judges before, right? Because if you're in a provincial third, fourth tier city, they couldn't find judges before because people who can pass the exam you got to pass to become a judge don't have any interest in staying in fourth tier cities, right? So there's over time this will evolve, and I think we're seeing legal professions develop not just in the first tier and second tier cities, but in the third tiers. But still, right, for the, you know, still a pretty tough exam to pass, 20% pass or so. And for the people who pass, they're not going to stay in, you know, less developed areas. So that's the first point. The second point is I do think there's another story here, which is what does this all say about how the state views lawyers? And that's a really big issue. And I think the state is showing increased signs of distrusting lawyers generally. We see this in some of the petty regulation. You know, Chengdu was on, people have been seeing this on Weixin. WeChat a couple weeks ago, they issued a regulation saying lawyers have to report to the local justice bureau any plans to travel overseas. Clearly illegal, no legal basis. And we're seeing this in the debate. There's a debate right now, and been some in China have suggested that China should have different tiers of lawyers, right? And they're going to different ranks, and only certainly high quality lawyers are going to be able to do death cases and things like that. And, you know, so my response to that is, you know, who knows what is going on? But I think that some of this may be blind copying of other systems, but some of this is, I think, a suggestion that there's that some of the concern about rights lawyers is now rubbing off into how the state views lawyers more generally. I think that's a larger question going forward, right? Does the state really trust lawyers? So, you know, I gave a comments at a conference in December in Beijing, which were all about how you need more lawyers in the system, and lawyers play a greater role if you're going to have people actually trust the system. So, but I think this is an interesting issue to watch. So separate from the sort of job generally, I think there's a larger question of is China moving from fairly, I think, high degree of comfort with having more and more lawyers to actually being a little wary about having lawyers. And I think that's problematic. But I think it's a trend worth watching. I don't think we know the answer yet.